Mr. Brush,
Yes, Your Honor.
you ready? We're ready.
I am.
Would you like to reserve some time for rebuttal?
5 minutes, please.
You've got it.
Okay. May it please the court. My name is Robert Brush. I represent Anna Maria Cornine in this appeal of her dissolution of marriage. The salient facts are that this case was tried over 3 different days: October 24, 2018, November 2nd, 2018, and then February 19th, 2019. The trial court requested and received proposed final judgments and proposed parenting plans from both attorneys. Mine was sent in March 15th. Subsequently, there was no decision, and Judge Ward changed divisions in Sebring, and Judge McDaniel, taking over the family law, set a case management conference in this case. That was canceled when it was realized that Judge Ward had not yet ruled on the trial testimony and prepared a final judgment dissolution of marriage. That he finally did so August 27th, 2019, 6 months and 8 days after the last day of trial, February 19th, 2019. In that 6-month interim, numerous things happened between the parties, and both counsels sent to the court correspondence, requested case management hearings and the like, and nothing happened. And the problem is that these parties—
Look, let me just clarify, because I don't recall. Did you specifically ask in the request for case management for the court to reopen and allow additional evidence?
I don't recall, Your Honor.
Okay.
And
Okay,
that
go
might
ahead.
have—
I'm sorry to interrupt. That had been rattling around in my brain, and I wanted an answer. Thank you.
Sorry, I don't know. It may have been requested by the other attorney. But at any rate, these parties are virtually identical in that the husband during the marriage became a paramedic. The wife then at trial indicated that she wanted to become a paramedic and moved to Polk County, which had greater opportunities for her advancement. However, the former husband did a lot of things which were not particularly good things, none of which you can say about the ex-wife. The husband was fired from his job as a firefighter for the city of Sebring. He went to various parties and concerts with his friends instead of being with the child. He took the child on a cruise when he knew the child was sick. The child came back, double ear infection. He would take the child twice a week from Sebring to Okeechobee to spend the night with his girlfriend. And the party's minor child was born in May of 2013. She got to sleep in the bed with the girlfriend's daughter.
Mr. Brush, I just want to stop you just for a second and ask you to reflect actually on the argument you're making, because you're reciting to us testimony or evidence that you believe is favorable to one party and unfavorable to another, which sounds a lot to me like you're making an argument to us that we should reweigh the evidence. If that's, if that's the argument you're making, I think you understand the constraints that we're under, that we cannot reweigh the evidence. So I just ask you to be cognizant of that constraint on our review ability as you continue your argument.
Okay, I understand it's an abuse of discretion standard. But the point I'm trying to make here is that in the evidence, the wife comes out better than the husband because there's nothing about her that's wrong. There's no evidence of drug abuse. No
Mr.
evidence
Brush,
of
I mean, but that you kind of just said the wife comes out better. That's a weighing. That's an assessment of competing evidence, right?
Right, but I'm trying to
And
argue
you're asking us to now agree with that weighing, which it would be a reweighing of what the trial court concluded.
Okay, the trial court ended up with 80% of the time for the father and 20% for the mother.
Well, that may on its face be inequitable, and at first glance, it appears that it might be. But I read the whole trial. But let me get to your first point about taking too long to render an order and not having independent findings and things like that. But the record's clear that the judge didn't make any oral findings during or after the hearing. The judge asked both of you, I don't know if Ms. Henney tried it below, but you did, Mr. Brush. The judge asked you for closing arguments and you did not do that. You opted not to. So, and the judge also during the trial mentioned that he had 76 pages of notes, which included his notes about prior hearings and the notes regarding the testimony that was taken at the final hearing. So it's a little hard for me to say that this judge didn't pay attention and this order wasn't his own reasoning. And then secondly, all the correspondence you sent to the judge in the interim before the entry of the order, your letter, and I quote, told Judge Ward, I don't see any substantial change taking place, and you didn't ask for anything. You didn't ask for a rehearing, you didn't ask for a reconsideration. As far as you were concerned, it was fine. But now you're trying to argue to us that the judge should have reheard it because there's all this new stuff. So now when I go back to the trial, I read about the wife's father having a felony conviction for cultivating marijuana. He admits to smoking marijuana, at least till 2016. The child's hurt at the parents' house where they have a leather shop with toxic chemicals. Plus, they drive a van that only has a front seat and not a back seat for a minor child. And the wife moves the kid who's been going to school in Sebring her whole life and moves to Arcadia. And, you know, she's got to undergo 1,200 hours and 44 weeks of school. No days off for an 11-month period, 16 to 18 hours a week at the college or the hospital or the ambulance. So this judge is like, well, you know what? She's making good decisions for herself. But are these decisions in the best interest of the child? You're telling us the wife comes out better than the husband, but we're looking at this judge who was there looking at these people and listening to them, and he weighed it as best that he could. And we can't reweigh it. But to sit here and say that all the evidence favored the wife, I don't see it that way.
Well, I guess my argument is she's certainly no worse than the husband on the evidence. And so, and the evidence was always...
You argue about her move. Yeah, her move benefited her, but according to Judge Ward, it didn't benefit the child, and that's the focus.
But Your Honor, she lived the entire time in Sebring in the marital home, which she was paying for by herself, and for which Judge Ward did not give her half credit for the last 6 months from the time of the final hearing until he entered the order. I don't know how she was supposed to know that that was going to happen. So at any rate, my point is in the cases, the record has to sustain the ruling, and that my position is it doesn't sustain her getting 20% of the time. And since she's 24 hours on, 48 hours off, she will see her child effectively not very often at all. So she's precluded from having a meaningful relationship with her child because of her work schedule, which is identical A shift to the husband. And if we look at the other concern about the delay is looking at some of the inconsistencies in the final judgment. In the final judgment on page 3, paragraph D, the judge finds the child has not had a stable home environment. When in fact, the child had lived at that marital home in Sebring and continued to live there with the mother when she had time sharing. And then with the father at his mother's house in Sebring or at the girlfriend's house. Then in paragraph E, the judge writes the parents live and work in different counties. The only evidence the judge had was that the father was living and working in Highlands County, and that the mother lived in Highlands County in the marital home, which had not yet been sold pursuant to his order. So that's an inconsistency. And his reasoning, which he's supposed to set forth pursuant to case law, he just says a strictly equal time sharing plan is no longer viable. Child has reached school age. The parents live and work in different counties. That's not true. And as such, the court finds in the best interest of the child to reside primarily with one parent during a school week. There's no basis set forth for him making that determination to the extent he made it 80-20. Then you go down further on the same page, the child's doing well in school. Well, okay, she's doing well in school, but allegedly didn't have a stable home environment, even though the marital home was sold after the final judgment. Then, totally inconsistent, and on page 4, in subfactor K, the court talks about the mother having to use parents and friends and others, including the husband's girlfriend, apparently, for babysitting. And the court says that she's unable to provide the minor child a consistent routine. But then the court goes on following page 5, factor O, and says during the course of the marriage, both parties relied heavily upon each of their parents for child care, and they're equal as this statutory factor. So how can they be equal in O, and somehow by her using those people for babysitting, they're not equal in K, when these people both basically have the same job? Then the court in P, on page 5 of the final judgment, says both parents have the capacity and disposition to participate and be involved in child's school and extracurricular activities. In the brief, from the evidence, we pointed out husband didn't go to the first play of the child. He didn't go to the child's field trip. He never took her to gymnastic lessons. He let the mother see the child one hour on her birthday, and then the following day took her away from a hockey game she was going to go to with her mother and others. These are not consistent findings. These are inconsistent. The evidence is inconsistent with what the judge concluded. And when you have, you also have in M, court finding no evidence of child abuse or child neglect. I would submit that taking a child on a cruise that was pre-planned, when the child had an ear infection and came back with a double ear infection.
Are you seriously arguing that that amounts to child abuse or neglect?
To take a child with an ear infection on a cruise? Yeah, I think it's irresponsible.
Counsel, you do realize that we have reviewed actual child abuse cases before. Make your argument however you think best, but.
Well, it's child abuse or neglect, Your Honor.
Okay.
At any rate, under the case law, the facts have to support the judge's findings. And when 6 months go by, which by the way, 6 months under judicial rule of procedure 2.250 is the time that's expected to take a contested divorce case from beginning to end. So the main argument is that the evidence does not support the judge's ruling on time sharing, and the inconsistencies when added with the delay caused concern that the judge had an adequate memory of the case. He may have been great at taking notes, but nobody can take notes like a court reporter and watch the witnesses and do all that. So it's just not possible he wrote down everything. And of course, he's not going to remember as well 6 months down the road as he is if he'd done it in the first 60 days, which the Rules of Judicial Administration required him to do. It also doesn't appear, based upon the findings, some of which again are in conflict, inconsistent, that the court took into account the statutory requirement, the public policy of the state, that each parent has frequent and continuing contact with the child. Giving a first responder 24 hours on, 48 hours off, 20% of the time does not allow for frequent and continuing contact. There is absolutely no evidence in the record why my client should be limited to 20%, most of which she can't even exercise because of her job, which was heavily discussed during the trial and was discussed in proposed parenting plans submitted to the judge. Those things didn't make it in the file. We tried to call the clerk in Sebring and found out the judge had thrown those away, the proposed final judgments and proposed parenting plans. So, and then the statute also goes on, 61.13, to state that the only reason you should curtail shared parental responsibility is that that would be detrimental to the child. I don't know anything in the record that the mother did specifically that was detrimental to the child. And then, of course, the overwhelming concern is the best interest of the child. My client has a constitutional right to have a meaningful relationship with her child. This time-sharing plan entered by the judge on what I consider to be scanty to little evidence is not workable for my client. She's not going to have a meaningful relationship with the child. The child's half brother, that is my client's other child from another relationship, of which she has 60% of the time, is not going to be able to see his sister, even though everybody agreed the two of them should continue to be together.
Sir, you've got 5 minutes left if you wanted to save that for rebuttal.
Okay, I'll save that for rebuttal.
Okay, thank you. Henny?
Good morning, Your Honors. My name is Jean Henney, and I represent the father in this appeal from the final judgment of dissolution of marriage. The mother raises 6 issues on appeal. The first issue has to deal with the time-sharing plan. Of course, there's no presumption for against the mother or the father. There's no presumption for against a particular parenting plan. There was 3 days of lots of witnesses, testimony, evidence, and the trial judge, for purposes of this appeal, made several factual findings that were supported by competent substantial evidence. The first one, as Mr. Brush has already pointed out, was that a strictly equal time-sharing plan is no longer viable in this matter. The child is school age and the parents live and work in different counties. As such, this court finds it to be in the best interest of the child for the child to reside primarily with one parent during the school week. This is a discretionary decision that was based on competent substantial evidence because both the mother and the father requested majority time sharing during the school week for the child. So now the trial court has to decide father or mother. And the trial court weighed, as I said, 3 days worth of evidence and testimony and made.
Let me just stop you. I thought I saw a proposed plan in the record where it was a week on and a week off, not both requesting primary.
Well, the mother, the testimony indicates that she presented 2 potential time-sharing plans. One was 60-40 and the other was 50-50 alternating weeks.
Right.
So the problem with the alternating weeks is that originally, throughout the marriage, the parties were both firefighters. They had shift A, shift B, shift C. Dad worked A, mom worked B. They were both off on C. When the parties separated, dad worked A, mom worked B. They alternated the child on C. So it was a 50-50 time sharing plan. That worked well until May of 2018 when the mother moved to Polk County, took a job in Polk County. And then she was assigned the A shift. So now they were both assigned the A shift. And it no longer worked. So in the summer, they split 50-50 time sharing because the child wasn't in school. So the trial court looked at the evidence that was presented and made a decision that to keep the child in school in Sebring was in the best interest of the child and that she should reside with one of the parents. The mother was at the time residing in Sebring, working in Polk County up here and relying on primary caregivers in Arcadia, DeSoto County. So if we left the child in school in Highlands, which was determined to be in the best interest of the child, then the trial court exercised its discretion and found that that would be with the father, who had lived, worked, and relied on caregivers that were all in Highlands County. The other problem with the mother is that she had committed to, when she took the job in Polk County, she committed to an intensive paramedic training program that would not allow her hardly any time sharing because she would be committed, there was testimony about what that required. So the trial court had to make a decision, a discretionary decision, and found that it was in the best interest of the child to exercise majority time sharing with one person in Sebring, and that was with the father.
Okay, thank you.
You know, as these cases go, there were no perfect parents, and there's no perfect solution. And so,
Well, right, unless the two parents want to get together and agree to do what's best for the child. I mean, you don't have to let a third party make these decisions for you.
exactly. But that was 3 days of letting the trial judge make the decision for you. And he weighed the evidence, which comes to the second point about the 6 months taking to enter the final judgment. The judge took incredibly detailed notes, and there were about 3 or 4 times during the continuated hearings where the attorneys would say, I don't remember if that was already brought up, or I don't remember where we were exactly. And the judge would look at his notes and come up with exactly what the court reporter subsequently transcribed. So his notes were very accurate. And as Judge Sleet pointed out, at one point he says, I found that answer on page 76 of my notes. So there could have been hundreds of pages of notes. So in a 6-month delay without more would not require a reversal. And in this case, there's just not more. There's nothing in this appellate record that would indicate the failure of the trial court to consider the pertinent facts. And this trial court definitely considered the pertinent facts. The mother in her brief also raises the denial of her motion for rehearing. She did file a motion for rehearing. She did ask for the evidence to be reopened as to 3 particular issues. The trial court exercises discretion and denied that motion. Issues were not specifically raised as points on appeal. So there was no abuse of discretion in denying the motion for rehearing. The 4th point on appeal she raised was a reversal to mirror the time-sharing plan with the child's stepbrother. There's no legal authority that the trial court has to coordinate time-sharing plans with step-siblings. This would be, in this era of blended families, that would be just a nightmare for a trial court and basically impossible. The other problem is that it makes no sense in this case, because when the parties were separated, the mother allowed the biological father to have the majority of time with her son from a previous marriage. So that father testified at trial and said that the mother had only visited that child 3 times. So she had minority time sharing with that child. So actually what the trial court did in this case was award minority time sharing with the child. So they do mirror one another.
Let me ask you, because that was actually something that had me kind of scratching my head a little bit. It does seem like, and correct me if I'm wrong, that what the trial court ultimately entered for this child does seem to mirror what was going on with the wife's other former or older child. And is that at all problematic? Given the light of your argument, which is that there's no authority to have them mirror when they're half siblings. Mm-hmm. So if the court in effect did it to the wife's, perhaps to the wife's detriment, is that problematic?
I don't believe it's problematic at all, because the mother was very inconsistent with what her future plans were, and also as it related to her son. So she technically had majority time sharing with her older son, but she gave it up to the biological father. The biological father says when he testifies, I don't want to mess up anything because I want to keep majority time sharing. So I don't think the trial court erred in any consideration or lack of consideration coordinating or not coordinating the son with the daughter because the mother wasn't sure what she was doing. So it was not an abuse of discretion in any way, just to do a time sharing plan that worked, for the child in the instant case. Does that answer your question? Does that make any sense? And then the mother also argues error in failing to enter a phased-in time-sharing plan, one for while she was going to paramedic school, which would, of course, give the father, even probably more than 80-20% time-sharing, and then phase into another plan. And of course, the case law says that you have to do a time-sharing plan based on the evidence presented and the best interest of the child at the time it's entered. And then the final issue that she raised on appeal was the failure for the trial court's partition of the marital residence. There again, this was a discretionary decision. It was supported by the evidence at trial, considering there were liens on the property by the roofing company. It was necessary to do an equitable distribution of the marital estate. And there was really no evidence that the mother could afford or had the credit to refinance the property. Her request for relief is a remand to permit her the opportunity to obtain refinancing for the property. And the trial court, of course, made a discretionary decision that it was in the best interest to partition the property. Although reasonable people may differ regarding any of these 6 issues, the trial court's extensive factual findings were based on competent, substantial evidence, and the decision was in no way arbitrary, fanciful, or unreasonable. And therefore, the father would request that this court affirm the final judgment. There's no other questions. I have no further arguments.
Okay. Anyone else? Okay, thank you. Mr. Brush, you've got about 4.5 minutes.
Okay. In looking at the record as a whole and comparing it to the final judgment, I don't think anyone can seriously argue that the wife got a fair deal based on the evidence at 20% time sharing, which is going to be eaten up by her work schedule. All this was known and heavily discussed. She was attacked repeatedly during the trial for trying to better herself, to get a better job, to make more money for herself and her family. There effectively is no difference between her and her husband, either in their work or anything else. And there was absolutely no negative information about the wife personally that related to her and the child. So I don't know how we can look at this when the public policy is for both parents to have meaningful time with their child. It just didn't happen. And because of the delay, that leads to the belief that the judge did not remember as much of this as he should have. Looking at some of the cases, Tom Zach reversed a case where the visitation was unworkable. This visitation is unworkable, and the judge well knew that because of all the testimony regarding shifts and how the mother is going to not be able to see the kid even when she's given the time to see the child. The court didn't include a right of first refusal. So I don't know how it's in the best interest of the child to effectively take the child's mother away from her, to let her see the child maybe 10, 15 hours a month, depending upon her schedule. It's not supported.
Is there anything that prevents the parties from reaching a different accommodation between themselves?
Other than pure meanness, no.
Mm-hmm.
And at one point, they had a 50-50 going during the summer, and the husband had texted he was okay with that. He'd have been okay with that. And I don't know, he talked to his attorney or something, and then he wasn't okay with that. So she effectively has been deprived of her constitutional right to help raise this child with a combination of the work schedules. And I don't know why she should be treated any differently than the husband. And if you carry the argument made at trial against her, that it's somehow wrong for her to want to try and better herself, I mean, it's essentially discrimination against women. because they do the same kind of work. And also in the case law, the record must reflect that the custody determination was made in the best interest of the child. I do not believe this record reflects that 20% as eaten into by the work schedule reflects that. And then in Perez versus Fay, which is the second DC opinion, 2015, the court states that the Supreme Court has recognized a constitutionally protected inherent right to meaningful relationship. Thus, time-sharing privileges should not be denied to either parent as long as the parent conducts himself or herself while in the presence of the children in a manner which will not adversely affect the children. There's not one scintilla of evidence that the wife ever did that, as opposed to the husband, which is debatable evidence, but there's just no reason in the record to distinguish between one or the other. Because of the constitutional right to a meaningful parent-child relationship, there must be competent, substantial evidence in the record that demonstrates that any restrictions or limitations on time sharing are in the best interest of the child before those restrictions will be sustained. And my point is simply that there is none in the record, and there is none in the final judgment, which in itself contains inconsistencies. Some of the case law regarding delays, as little as 3 months can be enough if there are inconsistencies. And there are inconsistencies because, as I said, everybody lived in Sebring and worked in Sebring except the mother. Both of them relied upon parents and friends as babysitters. But that was the basis by which the court said that my client was unstable. And a page later, he says they both rely upon these people, and to work, they're going to have to rely upon these people for babysitters. So when you look at the totality of the evidence and the findings, they don't seem to match up. And they clearly, despite all the testimony about 24 hours on, 48 hours off, the time sharing at 80-20 is just not workable. Also, as far as the credit on the marital home is concerned, the judge gave my client credit for the mortgage payment she made. The husband wouldn't make the mortgage payments, wouldn't make his half, but the judge didn't give her credit for the time period from the last hearing until he entered the final judgment. And there's no reason given for that. That she had exclusive.
The reason for that was because she was living in the house.
She was, but she lived in the house the entire time after the separation and paid the mortgage the entire time. So drawing a distinction between 1 month and another month, especially 6 months when the judge is not making a decision, doesn't seem to be supported by the facts.
All right, Mr. Brush, thank you. You're at the conclusion of your time. Thank you both. That concludes this argument. Our next case this morning is Bernstein versus Worrell.